Do you know which Chief Justice this is? I'll bet that you don't. This is the 16th Supreme Court Chief Justice William Rehnquist, who is remembered as one of the most successful Chief Justices of the Supreme Court. Rehnquist was born in Milwaukee, Wisconsin in 1924. His parents were William Benjamin Rehnquist, a conservative Republican that was a sales manager for a printing, equipment, and paper sales office. His mother was Marjorie Peck Rehnquist, who was a director for a small insurance company and a local civic activist. Rehnquist's educational career began at Shorewood High School, and then he went to Kenyon College before attending Stanford and eventually Harvard University. After briefly attending Kenyon College for one semester, Rehnquist joined the U.S. Army Air Forces during World War II, where he never saw any combat. Rehnquist then attended Stanford University, where he received a Bachelor of Arts and a Master of Arts in Political Science. Rehnquist then attended Harvard University, where he received another Master of Arts in Government. Eventually, he returned to Stanford University and graduated from the Stanford Law School. During his time at Stanford Law School, he met Sandra Day O'Connor, who would later serve on the Supreme Court with him, and during their time at Stanford, they briefly dated. Rehnquist's professional career began as a law clerk for Robert Jackson, a moderate on the U.S. Supreme Court. Eventually, he moved to Phoenix, Arizona to begin a private practice. And from there, Richard Nixon won the presidency in 1968, and Rehnquist moved back to Washington, D.C. to serve as a deputy attorney general for the Justice Department. Nixon eventually nominated him as an associate justice of the Supreme Court. In 1986, when Chief Justice Warren Burger retired, Ronald Reagan named Rehnquist as the Chief Justice of the Supreme Court. Rehnquist was involved in several landmark cases, including Texas versus Johnson, where he wrote a dissenting opinion on the court ruling allowing flag burning being protected by the First Amendment, and Kelo versus City of New London, where he wrote a dissenting opinion that allows local governments to force property owners to sell their properties to make way for private economic development that will increase property taxes. This was a violation of the Fifth Amendment protections of eminent domain. But his most controversial case was Roe versus Wade, where he wrote a dissenting opinion on the majority decision to make abortion legal. Interesting facts about Rehnquist are that during World War II, he was stationed in North Africa as a weather observer, and as a clerk, he encouraged Associate Justice Robert Jackson to support overturning Plessy versus Ferguson and supporting the concept of separate but equal. He was often referred to as the Lone Ranger because of his tendency to be on the opposite side of the majority in Supreme Court decisions. After 33 years' service in the Supreme Court, Rehnquist was diagnosed with thyroid cancer, but refused to retire and remained Chief Justice until his death in September 2005.
Plessy versus Ferguson, 1896. This case involved Homer Plessy, who was a successful African-American businessman, who was part of the Committee of Citizens, and John Ferguson. This case happened in 1896, months of April, and decided in May. This case took place at the Louisiana Supreme Court, which is the state's highest court located in the city of New Orleans. Plessy, being a successful black and white Louisiana businessman, had acted on behalf of a committee of citizens, a group of New Orleans residents that technically told him to challenge Jim Crow laws. He intentionally broke the law to initiate a case by sitting in a whites-only seat section on a train, then refused to get up, which caused him to go to jail. Plessy's lawyer argued that the Separate Car Act violated the 13th and 14th Amendments. Louisiana judge found that Louisiana could enforce this law because it affected railroads within its boundaries. This case went to court because it was thought to be breaking the law or violating the 13th and 14th Amendment. It is the right of each state to make rules to protect public safety. Segregated facilities reflected the public will in Louisiana. A separate but equal facility provided the protection required by the 14th Amendment and satisfied the demands of white citizens as well during this time frame. John Henry Brown from Michigan decided the 71 decision of the court that upheld the Louisiana law requiring segregation. Brown said that this act did not violate or break either the 13th or 14th Amendments. He stated that the 13th Amendment applied only to slavery, and the 14th Amendment was not intended to give African Americans social equality, but only political and civil equality with white people. He argued that if civil and political rights of both races are equal, one cannot be inferior to the other. The arguments in the case revolved around the 13th Amendment and the Equal Protection Clause of the 14th Amendment. It impacts American society because Louisiana law requiring segregated seating violated Plessy Rights and Protection Clause. It was thought to change to protect Louisiana, as the judge said. Brown states that legislation cannot change public attitudes and that the attempt to do so will only accentuate the difficulty of the present situation.